Breaking news that just hit the courts, and I need you to hear this right now. The Department of Justice just reversed their position on suppressors and the National Firearms Act, and within hours, a unanimous decision dropped that could change everything for every single gun owner in America. This is not a drill. The DOJ flipped, the courts responded immediately, and what happens next could either dismantle decades of unconstitutional restrictions or cement them forever. If you own a suppressor, if you've ever thought about owning one, or if you care about the Second Amendment at all, you need to understand what just happened in the last 48 hours because the timeline on this is moving faster than anything we've seen in years. And if you're new here, welcome to Firearm Hub, your trusted source for Second Amendment law breakdowns, Supreme Court rulings, and real pro-freedom updates you won't hear anywhere else. Now, before we dive deep into this bombshell, I need to ask you for one quick favor that keeps this channel alive and keeps these updates coming to you faster than the mainstream media will ever cover them. Hit that subscribe button right now. And here's the thing. YouTube has been aggressively unsubscribing people from Second Amendment channels like this one. It's been happening for months, so do me a favor, scroll down right now and check if you're still subscribed. If that button says subscribe, click it. If it says subscribed, you're good. But check the notification bell too because they love to turn those off. We're fighting an uphill battle just to get this information to you, and your subscription is literally the weapon we use to bypass the algorithm that wants to bury pro-freedom content. Alright, let's get into what just happened because this is moving at lightning speed and the implications are staggering. We're talking about a case that involves the National Firearms Act. The DOJ completely reversing their legal position on whether suppressors are protected arms under the Second Amendment, and then a federal appeals court issuing a ruling that every gun rights advocate needs to understand. The case is United States versus Peterson, and it's been bouncing around the Fifth Circuit Court of Appeals. But what just happened is unlike anything we've seen in recent memory. The Trump DOJ filed a brief reversed decades of government policy and declared outright that suppressors are constitutionally protected arms. They said it, in writing, in a legal filing. But here's the twist that nobody saw coming, and here's where this gets complicated and frankly infuriating. Even though they admitted suppressors are protected by the Second Amendment, they're still arguing that the NFA's restrictions are constitutional. They're trying to have it both ways. They're saying yes, suppressors are arms, yes, they're protected, but the government can still tax them, register them, and control them under the NFA because it operates as what they call a shall-issue permit system. And the Fifth Circuit just agreed with them, unanimously. Stay with us until the end because what I'm about to explain is going to make you realize just how precarious our rights are right now, even under an administration that claims to support the Second Amendment. You deserve to know this. And you deserve to understand the legal gymnastics that are being used to justify continued infringement. Let me walk you through exactly what happened here because the details matter, and the timeline is crucial. Back in 2022, federal and state law enforcement, we're talking about roughly 50 officers, ATF agents, local agents, the whole intimidation squad, they executed a warrant at a man's home in Louisiana. His name is Mr. Peterson. He had a home-based federal firearms license, he was running a legal business, and they raided him over alleged record-keeping violations and some issues with firearms that were supposedly later found at crime scenes. But out of this entire massive raid with dozens of armed agents descending on his property, the one thing they charged him with that led to this legal battle was possession of a single solvent trap. One solvent trap. It was in his bedroom safe. It wasn't registered under the NFA as a suppressor. And because of that, they hit him with NFA violations. Now, Mr. Peterson did what any informed American should do when the government overreaches. He filed a motion to dismiss based on the Second Amendment. He argued that the NFA's restrictions on suppressors are unconstitutional. The district court denied his motion. So he appealed to the Fifth Circuit, and that's when the first ruling came down. And it was bad. The Fifth Circuit's three-judge panel sided with the Biden ATF and the Biden DOJ at the time. They ruled that a suppressor is not a necessary component of a firearm, that it's not required to make a firearm useful and functional, and therefore it's not protected by the Second Amendment. That ruling was a disaster. It was a betrayal of the clear text and history standard that the Supreme Court gave us in Bruin. So Mr. Peterson and his legal team filed for en banc review. which means they wanted the full Fifth Circuit to reconsider the case. But then something changed. The Trump administration took over, the DOJ changed hands, and in their first brief to the Fifth Circuit en banc panel, the Trump DOJ did something shocking. They reversed policy. They stated outright that suppressors are arms and that they cannot be outright banned because they are protected by the Second Amendment. This is huge. This is the federal government admitting what we've known all along. Suppressors are bearable arms. They're accessories that enhance the functionality and safety of firearms. They protect hearing. They reduce noise pollution. They're common. They're in widespread use. Under Bruin, they should be protected, period. But here's where the DOJ's position gets slippery, and where gun owners need to pay very close attention. Even though they admitted suppressors are protected arms, they're still defending the NFA. They're arguing that the NFA's taxation and registration system doesn't amount to an outright ban, and therefore it's still constitutional. They're saying it's just a permit system, a shall-issue permit system, and that under the dicta in Bruin, specifically the concurring opinion by Justice Kavanaugh, permit systems are allowed as long as they use objective criteria like background checks, fingerprints, fees, things like that. So the DOJ is trying to twist Bruin's language about concealed carry permits and apply it to the NFA's suppressor registration scheme. And the Fifth Circuit bought it. After the case went back to the three-judge panel with the DOJ's new position, the panel still upheld the NFA. They ruled that the NFA is constitutional because it operates like a shall-issue permit. They said it's just a modest burden, just a modest burden. Think about that. You have to pay a $200 tax, submit fingerprints, submit photographs, fill out detailed ATF forms, wait months or sometimes over a year for approval, and if you mess up any part of that process, you're looking at 10 years in federal prison and a $250,000 fine. And they call that a modest burden. It's absurd, it's infuriating, and it's dangerous because this ruling now sets a precedent that could be used to justify permit schemes for any constitutional right. I promise you this part is critical. If the Fifth Circuit's logic stands, if this twisted interpretation of Bruin becomes the standard, then the government could impose taxation, registration, and waiting periods on any firearm, any accessory, anything related to the Second Amendment, and they'll just call it a shall-issue permit. They'll say it's objective criteria, it's a modest burden, and it's constitutional. This is how rights die. Not with an outright ban that everyone can see and fight against, but with bureaucratic schemes that slowly strangle your ability to exercise your rights until only the wealthy and the patient can afford to comply. Now, Mr. Peterson's legal team fought back. They filed a petition for en banc review, arguing that the panel mischaracterized how the NFA actually operates. They're saying the NFA is not like a concealed carry permit. It's a taxation and registration scheme that was originally designed in the 1930s to price certain firearms and accessories out of reach of ordinary Americans. Back then, $200 was multiple months of wages. It was a de facto ban. And even today, the process is onerous, invasive, and designed to discourage people from exercising their rights. The petition argues that the panel wrongfully equated the NFA with a shall-issue permit, and that the case deserves full en banc review by all the judges on the Fifth Circuit. So the question became, how would the Trump DOJ respond to this petition? Would they continue to defend suppressors as protected arms? Would they push for en banc review and argue that the NFA is unconstitutional? Or would they defend the NFA and ask the court to deny review? Well, we just got the answer. The Trump DOJ filed their response, and they're asking the Fifth Circuit to deny en banc review. They're defending the NFA. They're arguing that the panel correctly held that the NFA's restrictions do not violate the Second Amendment. They're saying the NFA imposes only a modest burden, and that it's consistent with historical laws regulating weapons that were particularly susceptible to criminal misuse. They're endorsing the panel's decision to compare the NFA to shall-issue licensing schemes. And they're downplaying the precedent this sets by claiming that this ruling wouldn't allow the government to impose taxation and registration on every privately owned firearm in the nation. But here's the problem. Once you accept the logic that the government can tax, register, and delay the exercise of a constitutional right, as long as they eventually issue approval, you've opened the door to unlimited regulation. There's no limiting principle. If they can do it to suppressors, why not semi-automatic rifles? Why not handguns? Why not ammunition? The Fifth Circuit's ruling and the DOJ's endorsement of it create a blueprint for gun control that doesn't technically ban anything, but makes exercising your rights so burdensome that most people won't bother. And that's exactly what the gun control lobby wants. This fight is far from over. The petition for en banc review is now in front of the full Fifth Circuit. They'll decide whether to take up the case or let the panel's ruling stand. If they deny review, the next step is the Supreme Court. Mr. Peterson's team could file a petition for certiorari, asking the Supreme Court to take the case and decide once and for all whether the NFA's suppressor restrictions are constitutional. But here's the concern. Even if the Supreme Court takes the case, the Trump DOJ has shown that they're willing to defend the NFA. We've seen them do it in this case. We've seen them do it in another case called Rush and Robinson, which deals with the NFA's restrictions on short-barreled rifles. The DOJ is drawing a line. They're saying suppressors are arms, but the NFA is still constitutional, and that position could influence how the Supreme Court rules. They didn't expect this to happen. Nobody expected the DOJ to flip on whether suppressors are arms. That was a huge win. But nobody expected them to still defend the NFA either. This is a turning point for gun owners because it exposes the reality that even under a pro-Second Amendment administration, the bureaucracy and the legal establishment are deeply invested in preserving the NFA. There are billions of dollars in compliance costs, tens of thousands of NFA items registered, entire industries built around navigating the NFA process, and a law enforcement apparatus that uses the NFA as a tool to prosecute gun owners. Dismantling the NFA would be a seismic shift, and there are powerful interests that don't want that to happen. Stay informed and engaged. Your Second Amendment rights are always under attack. Courts across the country are deciding the future of these rights, and the outcomes will affect your children and grandchildren. Don't assume your rights are safe, even with a favorable administration or Supreme Court. Take action. Share this video, discuss the case with other gun owners, and let your representatives know you oppose the NFA and support full Second Amendment protections. Public pressure matters. Silence allows the government to chip away at your rights. We'll keep covering this case and other major Second Amendment issues, from ATF rules to Supreme Court developments. Your support, views, likes, comments, and shares strengthens the movement. Stay strong, stay informed, and stay armed. Subscribe and hit the bell for updates. Freedom isn't free. It must be defended every day.